So our final presentation today focuses on applications based on adverse possession. Our presenter is Frank Wall. Frank is an Assistant Principal Officer in our Western Region Legal Services Unit. He's a qualified solicitor and joined the PRA in 2017. Welcome, Frank.
Thanks, David, and good afternoon to everyone. Now, this presentation will deal with applications based on adverse possession. And in a similar vein to the previous presentations, it will focus on giving practical guidance as to what you, as lodging solicitors, should consider and lodge when making such applications. So, when we talk about applications based on adverse possession, what are we talking about? Well, there are two types of application. Firstly, there is a Form 5, so where an application is for first registration and the title is based on possession, an affidavit in Form 5 of the 2012 rules should be completed, sworn and lodged. And secondly, there is a Form 6, so where an application is for registration. In other words, it involves registered title, and the title is based on possession, a Form 6 should be lodged. And Form 6 applications can also be referred to as Section 49 cases, in reference to Section 49 of the 1964 Act. So therefore, as a lodging solicitor in a possession case, the very first matter to consider is whether the land is registered or unregistered. So, when you know what type of application you are making, be it a Form 5 or a Form 6, what do you need at a minimum? Well, no such application should be lodged without the following: a Land Registry Form 17, signed by an individual practicing solicitor and dated. Land Registry fees, €500 for a Form 5 and €130 for a Form 6 application. For a Form 5, a Land Registry compliant application map clearly identifying the application property is required in every case. And just on that point, if the map also identifies other property, for example, property the subject of an associated Form 1 or 2, just ensure the various plots are differently marked. Now, in the case of a Form 6, there is no requirement to lodge a map where the application property comprises an entire folio or the entirety of a folio plan. However, if the application property comprises portion only of a folio or of a plan, a map must be lodged. And lastly, there's the Capital Acquisitions Tax Certificate, and this certificate has to be lodged for every application based on possession, both Form 5 and 6, and it should always be enclosed on initial lodgement. Now, the CAT cert can be dealt with in one of two ways. There is the Revenue Form IT-76, which involves self-certification by a solicitor. And there are three circumstances where this can be used, one of which, and probably the most common, is where the value of the land does not exceed €19,050 and the area of the land does not exceed 5 hectares. And that form should not be submitted to revenue before lodgement to ourselves. The alternative then is a Revenue Form CA12, and unlike the Form IT-76, that must be submitted to revenue before lodgement to ourselves. And just when completing a CA12, ensure to accurately record on page 1 the details of the person that the applicant is going into possession against, and then accurately record on page 2 the details of the application property. So the address and the acreage that are recited on the revenue form should mirror the details on the application map. And if you lodge all of those things properly completed, a Form 17, fees, affidavit in Form 5 or 6, a map if required, and a CAT certificate, you're off to a good start and you'll already be ahead of the curve in terms of applications lodged. So, what does a properly completed affidavit look like? Well, in paragraph 1 of the Form 5, Ensure that the application property is clearly referenced by reference to its location, for example, the townland, the barony, the county, and also by reference to the application map, and input the period of possession. For a Form 6, it is the very same. However, as mentioned previously, reference to a map may not be necessary. And then we have the all-important paragraph 2. Now, it is for an applicant to prove the facts on which they base their claim, and it is in paragraph 2 where this is done. So the full facts of the claim with all pertinent information have to be set out here. Your paragraph 2, it should be comprehensive and detailed, perhaps running to several pages, and subparagraphs 2A, 2B, etc. should be used. And the same then for a Form 6. So here comes the text-heavy slide. I've set out here the key components or ingredients of a claim for adverse possession that paragraph 2 needs to deal with. Now, I won't go into detail on this, as the focus of the presentation is on the practicalities of these applications. However, in short, you need to demonstrate possession for the required statutory period, demonstrate who is being dispossessed, and establish the nature of the title against which possession is being claimed. Now, this last point, however, does not have to be addressed in a Form 6, as in the case of registered land, the title is already known. So, back to drafting the affidavit. Paragraphs 3 to 7 of the Form 5 and paragraphs 3 to 6 of the Form 6 contain standard averments that must be included. When drafting, just adhere to the form template, retain the paragraph numbering, and deal with the text in brackets as appropriate. And then lastly, the jura, very simply, it should be sworn, not declared, dated, and the person identifying the deponent should be identified. So hopefully you now have a sense of what application to make, what minimum documentation to include, and how to draft the relevant affidavit. So in terms of actually structuring your applications, I'll just go through some practical pre-lodgement matters to consider. So firstly, if the title to a property for first registration comprises distinct parts, so a portion comprises documentary freehold title and a portion comprises possessory title, we recommend that you lodge separate applications, dealings in respect of the distinct parts. So a standalone dealing for your Form 1 and a standalone dealing for the Form 5. If you do otherwise and bundle it all together under one dealing, it does not save on the fees payable, and the registration of the documentary title will likely be delayed by the possessory portion. Secondly, where an application property comprises several plots of ground. So, for example, an individual might be in possession of a number of plots of agricultural land in a particular locale. Now, where the history of possession of the various plots is the same, a single Form 5 or 6 can be lodged. However, if the historical possession differs, a separate Form 5 or 6 for each plot should be completed. And then, turning to personal representatives. Now, while we frequently receive applications lodged on behalf of a per rep, there is no provision in our Act or rules to register a per rep as owner. However, where it is averred that there is an imminent sale, we may agree to register a per rep. And if we do so, an inhibition will be registered on the folio, inhibiting all dealings except a transfer for sale by the registered owner as per rep. Otherwise, the estate of the deceased should be administered and the persons entitled to the property should apply for registration. So those are just a few matters to consider in terms of how you actually structure your applications. Now, I have already touched upon the minimum requirements for lodgement. However, depending on the facts of your application, certain additional documentation will be required. So in a Form 5 application, and where the application property comprises rural land, a letter from the Department of Agriculture, Food and the Marine confirming whether the property was the subject of land commission proceedings is required. Now, such a letter is not necessary where the application is in an urban or even semi-urban area. Again, in a Form 5 application, where the fee simple ownership cannot be shown, or perhaps where there are questions as to the boundaries of the property, a certificate from the valuation office, together with an associated valuation office map, will likely be required. And that should show the occupiers and immediate lessors of the property and should reflect the history of occupation as claimed by the applicant. And lastly, in a Form 5 application, certain searches are required. 1, a Judgments Office search for lis pendens against the applicant and anyone else on title in the last 5 years. And 2, a Registry of Deeds search against the applicant and their predecessors covering the period of possession of each such person. Now, proofs corroborating and establishing an applicant's claim in both Form 5 and Form 6 applications will be required in the following cases. So firstly, successive squatters. Now, a squatter has a right, title and interest in a property based on their possession, which is good against everyone except the dispossessed owner. And as such, a squatter can pass that on to another by deed. So, for example, if Michael is in possession for 10 years and he executes a deed assuring all of his right, title and interest in the property to Katrina, who then enters possession and continues for 2 years, Katrina acquires the property. However, absent a deed from Michael, she could only rely on her possession. And then there's the related matter of the devolution of title. So, for example, where a parent goes into possession against the owner and dies, an applicant child would have to lodge proofs showing how the property has devolved to him or her. For example, a death certificate, the grant of probate, the deed of assent. And lastly, just some additional documents that you may consider lodging in support of an applicant's case. So, letting agreements. Possession of land can include receiving the rents and profits out of the land. So, if an applicant has let the property, lodge documentation evidencing the letting and provide the tenant's contact details for service of notice. A Finders International report can be useful for providing details of the departure through marriage or emigration or the death of a person previously on title. And lastly, evidence of the payment of grants to an applicant in respect of the property can be helpful. For example, in the case of the single payment scheme, aerial photographs showing a property as being the subject of a grant payment can be obtained and lodged. And while this is not conclusive evidence of exclusive possession, it is an indicator of same, as the department only ever pays one set of subsidies for a particular plot of land. Now, I'm going to jump forward to a point in time where all necessary documentation has been lodged and all rulings raised have been addressed. In other words, to a point where the applicant has established a prima facie case. It is at this point that notice is served on such persons as the PRA directs. So when you are taking instructions initially, it is important that both you and your client are aware that this will happen before any registration is effected. And serving notice ensures that persons whose interests are claimed to be barred or who may have an interest in the property are notified of the application and have the opportunity to contest it. Now, I've set out on the slide examples of notice parties, but this is very much a non-exhaustive list. The notice period for receipt of objections is 21 days from the date of receipt of the notice. And if no objection is received by us within that time, registration can proceed. However, if an objection is received, it is a different story. To begin with, there is the question of the format of the objection. So in the first instance, we will accept an objection by way of signed letter. And that is acceptable for the purposes of an initial consideration and also as the basis for providing a copy of the Form 5 or 6 to the objector. However, all objections must ultimately be made by way of affidavit, and that affidavit must disclose a valid legal ground of objection. A copy of a valid objecting affidavit will be provided to the lodging solicitor and a response invited. And just on this point, please be aware that the PRA does not facilitate lengthy exchanges of correspondence or argument and counter-argument between a lodging and objecting party. If there are conflicting claims of absolute fact on affidavit, it is not the function of the PRA to make a determination, and registration cannot proceed. And in that scenario, one of three things will happen. An applicant can withdraw their application. An applicant can request a formal refusal order that may be appealed to court. And if an applicant does neither, a formal refusal order will be made. And just as a final point, it's worth noting that if an objection relates to part of the property only, registration can proceed if the applicant agrees to exclude the property under conflict from the application. So, in wrapping up, I hope the presentation has given those of you who have stayed to the end a better understanding of the practicalities of these applications. There's a wealth of information available on the website, and I've listed some of the most relevant links on the slide. And just in particular, the legal practices contain the text of sample rulings, and it would be useful to look over them in drafting a Form 5 or 6. So I'll just finish up by thanking you all for your time, and I will now pass you back to David.